Mr. President, I hope you're prepared, and therefore I want to give the mic to you to give us your suggestions on your proposal. So thank you very much, Mr. President, and welcome.
Mr. Chair, you'll allow me to submit standing. Okay. Honorable Chair, members of this committee, I submit on behalf of the Law Society of Kenya, in particular and generally on behalf of the people of Kenya. Why are we here? We are here because a report made in June 2019 recommended various measures, the effect of which was intended to revive KQ. It is important that we set out from the beginning that the initiative towards this end was won by KQ. KQ itself is on its deathbed. Is it a viable solution to saddle KAA with the obligations of KQ? That is the fundamental question that underlies the background upon which the Law Society of Kenya opposes this bill in its entirety. In fact, we dare say that this bill is one that ought not to have been brought to the floor of the House. I will start with the constitutional foundation. Under Article 1 of the Constitution, there are established three arms of government, one of which is Parliament, with the power to legislate on behalf of the people of Kenya. The power to legislate is delegated power because the people of Kenya are entitled to exercise that power either directly or through their delegates. What then is the function of Parliament? The function of Parliament is elaborately set out under Article 95 of the Constitution. In particular, reading from sub-article 1 to sub-article 6, the National Assembly represents the people of the constituencies and special instances in the National Assembly. But what is fundamental is that all laws that are made by the National Assembly are supposed to be for the benefit of the people. We have set out in our memorandum several grounds upon which we rely to indicate the reasons as to why this bill must be withdrawn. I will just highlight a few of them now that we've been given very limited time. Generally, if we start at at page 5, we have indicated that this entire process is shrouded in mystery. It is shrouded in mystery because it has not been explained how sustainable and feasible this venture is. At page 5, there is no full disclosure of how this enterprise is to be undertaken and how it will be beneficial to the people of Kenya. In particular, you will note that in the report presented in June 2019, various stakeholders made their contributions. Primarily, these stakeholders were state agencies, and secondarily, the stakeholders were members of the public. You will note from the report that all the members of the public, totaling 44, and this you will find commencing from page 22 of your report. All the 44 members of the public indicated their opposition to the private investment initiative proposal by KQ. They said no. It has also not been explained why these views towards no have not been incorporated in the bill. Still, at page 6, there is a non-disclosure of the contracts, permits, leases, and other obligations of KQ. Also, it has not been explained how the unionizable workers will be accommodated in this venture. If I may take you to page 8, the effect of this venture will deny KAA a chance to enter into similar and viable concessions. Why KQ and KAA alone? No explanation whatsoever has been given. Fundamentally, still at page 8, the other intriguing question is whether the taxpayers should bail out a partly government-owned airline through secretive maneuvers, which in addition allow eventual exclusive takeover and monopoly of an airport that eventually serves its competitors. Kenyans, we have KQ, which you have indicated is dying. We have KAA, which everybody knows is prospering. You want to take the heart of KAA and give it to a dying KQ. It does not make commercial sense. It is not legally tenable. It is not based upon sound constitutional foundations. Let me now go to the specifics of the bill itself. This you'll find commencing at page 10 of our memorandum. Under part 2 of the bill, there is intended to be created the National Aviation Council. Now, look at the structure of the council. The cabinet secretary in charge of defense, the Air Force commander, the cabinet secretary in charge of interior and coordination of government, the president of the Republic of Kenya. This is a replica of the National Security Council. Why are we going that direction? You see, it must be understood that there was propriety in the need to privatize KQ. It was based upon a feasibility study. Have we been told how we have fared on as a public limited liability company? You want to saddle KAA with these obligations for another 30 years or so? It does not make sense. Secondly, on the specifics, there is a possible conflict in the discharge of the mandates by the Kenya Civil Aviation Authority in view of the proposed establishment of the National Aviation Council. The dichotomy doesn't seem to be clear. Further, under Part 3, there is established the Kenya Aviation Corporation with perpetual succession and with the corporate entity status. However, there is a very deliberate attempt to remove this entity, first, from the requirement of the Constitution insofar as public procurement is done, and secondly, from the Companies Act insofar as the governance of corporations is concerned. Let me take you to the Constitution so that we see where this problem lies. I'll take you to Article 227 of the Constitution, and this is fundamental, members of this committee. Article 227. It says, procurement of public goods and services. When a state organ or any other public entity contracts for goods or services, it shall do so in accordance with a system that is fair, equitable, transparent, competitive, and cost-effective. Then it proceeds, an Act of Parliament shall prescribe a framework within which policies relating to procurement and asset disposal shall be implemented and may provide for all or any of the following. Then it enumerates 4 requirements. And permit me to speak to Kenyans. This is what the Constitution provided. And this bill intends to remove all the entities created there under from the operation of this act. What is the secrecy? What is it that is being hidden from Kenyans? We have seen the fate of the SGR project. We have seen the fate of the Talo oil mining project. All these contracts are shrouded in mystery. We do not know them. Yet we depend upon members of the National Assembly to oversight the executive under Article 94 and 95. I'm disappointed with members of this committee. I'm disappointed with the National Assembly. They appear to be an elaborate enterprise to deprive Kenyans of gains that have been made under KAA. An explanation ought to be found. I'm about to conclude. Under formation of Kenya Airways as a subsidiary, Kenya Airways is among the new entities to be created under this law. However, the law is quiet about private commercial interests under KQ as currently constituted. Therein lies the primordial question. What is the problem bedeviling KQ? What contracts has KQ entered into? Is it a purchase of these aircrafts? Is it a lease of these aircrafts? Who is behind? And as you consider that point, notice the layering of interests. And in company law, we understand what layering means. It's a clear, deliberate attempt to conceal. And you, as members of the National Assembly, have an obligation that transcends your tenure in this respected house. What will you say 10 years from now, when the history of Kenya will document the fact that KAA was cannibalized under your watch? History will not judge you fairly. At page 12, we have documented irregular amendments to other laws. Remember, this House has been through this perilous path before, where omnibus amendments are intended to be made in specific statutes, the effect of which is to enable one item. It's not permissible. Because you want to pass this bill. After you've passed this bill, then you will start running after the carpet, looking for other laws that needs to be put in tandem with this bill. That is not what the people of Kenya expect you to do. Over and above our memorandum to the National Assembly, we did publish a notice in the local dailies. We've published it in the Daily Nation, we've published it in the Standard, and today we've published it in the Star. I will want to present to you what we've said about this, because publicity is the hallmark of fidelity. This is the representation of the sovereign of the people. Anything you do must be open, must be transparent and accountable to the people of Kenya. The more you look at this bill, the more you get the conviction that you need to do the right thing. And Mr. Chair and members of this committee, there is a famous world leader by the name David Cameron. He was the Prime Minister of the UK. He said whenever he had to be confronted with a question on whether to do right or wrong, he could call his father, and the father will tell him, son, always do the right thing. I ask you to do the right thing. Send this bill back to whoever originated it. We do not need this bill. Kenya has lost colossal amounts of monies through enterprises of this kind. As we speak right now, the Law Society of Kenya has gone to court on so many directives made by the executive, all of which it was our expectation that you will oversight and say no, that the Speaker of the National Assembly will do that which his predecessor, Honorable Kenneth Otiato Marende, did. Say no to the executive. You are here on behalf of the people of Kenya. You are not here on behalf of the executive. You are not here on behalf of interested groups who want to use this house to pursue their own private interests insofar as KQ is concerned. I would have wanted to speak until tomorrow because this issue grieves me, and it grieves me so much that I cannot understand why we're even having this discussion. It ought not to have been there. Thank you, Chair. Thank you, members of this committee. Thank you, learned friends and members of the public, for listening to me.
Thank you very much.